I'd like to acknowledge the traditional custodians of the lands that we meet on today. I'm on the land of the Gadigal people of the Eora Nation, and I'd like to pay respects to elders past, present and emerging, and any Aboriginal or Torres Strait Islander people watching the CPD today. We're fortunate to have Janet McDonald chairing the CPD, Commissioner Janet McDonald. And prior to her appointment to the New South Wales Industrial Relations Commission in August 2022, Commissioner McDonald practiced as a barrister right here at the 22 in the fields of employment and commercial law. And I know that she did many other areas of law as well. She's been very modest there. She was also recognised as one of the preeminent practitioners in the field of costs, having been a legal cost consultant prior to being called to the bar. Commissioner McDonald was regularly briefed in cost disputes and appeared in a number of landmark cost cases. She was a member of the Bar Association's Cost and Fees Committee for over a decade, remains the author of the commentary in Part 42 of the UCPR of the New South Wales Civil Procedure Handbook. And since her appointment to the Industrial Commission, 10 of her decisions have been published in the industrial reports, 8 of which were single instance decisions, which is an above average strike rate for the state commissioners. It doesn't surprise me at all. I've always enjoyed your drafting style. She was also a member of the full bench which heard the New South Wales state wage case in 2024 when the Commission's award-making principles were significantly revised, and the state wage case of 2025. And she's a member of the Commission's Rules Committee as well.
Thank you very much, Karen. It's a pleasure to be here this afternoon to speak to you all about a very interesting decision. I'd like to first of all introduce you to our two speakers. Firstly, we have Karen Jones, who is an experienced litigator. Indeed, she's a barrister here at Level 22 and also at Kate Shepherd Chambers in New Zealand. She practices across, obviously, both New Zealand and Australia in a broad range of civil and regulatory litigation and investigations. Her areas of practice include employment, discrimination and human rights, privacy, workplace health and safety, regulatory prosecution and general civil litigation. Karen has a specialty in trans-Tasman employment law. Having practiced extensively in each jurisdiction, she's familiar with the legislative differences and the complications faced by employers and employees. She's able to advise clients in both countries on their respective employment and workplace obligations and to clearly explain the legal framework that needs to be complied with, as you'll see demonstrated this afternoon. She's acted for employers, employees and unions. Karen has collective bargaining and industrial experience in both countries, and she's also defended underpayment claims for employers and regularly advises on award compliance. Karen and I actually met, more than 15 years ago in the James Ashby Peter Slipper litigation, when I was a barrister, junior to Justice Lee at the time, and Karen was our instructing solicitor. So that was when I first met Karen, which was a very interesting case indeed. Can I now introduce Brian Powles? Brian's a partner at Walter Baden, where he leads the workplace law team. A client-focused lawyer and an accredited specialist in employment and industrial relations, he advises employers throughout Australia on all aspects of employment law. Much of his practice is now focused on the interpretation of industrial instruments, assisting clients in the navigation of complex compliance problems with particular attention to practical application. Brian holds a deep fascination with the difficulties associated with bridging the gap between award interpretation and real-life payroll application. And gosh, if there's ever an example of those difficulties, it's this case. And has previously provided advice as a subject matter expert to a number of payroll software development projects. As a recent side project, Brian has founded a company and designed the software Wage Check, little plug there, which is a specialist program focused on payroll remediation and auditing projects. So together we will hopefully help you explore the decision of the full name of which is the Fair Work Ombudsman and Woolworths Group Limited Fair Work Ombudsman against Coles Supermarkets Australia, Baker against Woolworths Group Limited and Powles against Coles Supermarkets Australia. 190-page at least decision
over
of
800 paragraphs.
Okay, 800 paragraph decision of Justice Perriman in the Federal Court. We'll hopefully explore the decision from both a practical and an advisory angle. We'll structure the session by walking through the major components of the judgment, as Justice Perrin did, but with particular emphasis on the parts that have the greatest compliance implication for employers, namely set-off, annualised salaries, record keeping, Section 557C of the Fair Work Act, and some of the award-specific questions about overtime and agreement clauses. We'll finish hopefully with some practical observations, and perhaps we might have some time for questions, and we'll hopefully wrap up at around about 6:45. So, the decision was a hard-fought case, and I'm going to ask Karen to tell us, I suppose, to set the scene about the decision, really.
Yes, and I think some of the numbers for me were really mind-boggling in this case. So as we've heard, we had 4 proceedings all heard together, and they all involve employees in management positions at your supermarket and some department heads, and they're all covered by the General Retail Industry Award. That's key. Both Woolworths and Coles employed thousands of store-based management staff. Some of them worked only at one store, and some of them worked across many stores. I think Woolworths had managers stationed at a store, and Coles had sort of roving managers. And the central question that was being explored in each of these 4 cases was whether a contractual set-off clause that was contained in the common law contracts could lawfully absorb award entitlements such as overtime and penalty rates and allowances. And underneath that, there were some questions about record keeping that becomes key, the timing of payments, and Section 557C of the Fair Work Act, which is about the evidentiary onus. That becomes really important in this case. To give some scale, Woolworths at the time that this litigation commenced had already remediated over $300 million, and Coles was around $7 million. That has now gone well beyond those figures, and the latest thing that I read was that the estimates are that it will now reach $1 billion in remediation. So the price of groceries is definitely going up. We're also talking about underpayment of 19,000 Woolworths employee managers and around 8,500 salary managers. Salaried managers at Coles. Originally, it was a 3-year period, and that's now been looking, it looks like they're going to extend that as well. And what caused the key problem was that neither Woolworths or Coles properly tracked the entitlements that their employees were supposed to be getting paid, and they just wanted to pay them this lump sum salary. And the consequence was that the employees were being underpaid across a long period of time and across many penalties. And that's had, as we've heard, a significant impact on what they should have been paid.
Thanks, Karen. So, Brian, awards have been around for a long time, and this is an industry that employs a large number of people. I mean, as I understand, it's one of the larger employers in Australia if you combine the 2 supermarkets. How is it that there's so much uncertainty about what compliance look like? How did we end up here now?
It's an interesting question. And it is, it's the most prolific award. So it's I think 11.5% of award covered people are covered by this award. So it's number 1. And these are 2 of the largest employers. I think there's a general answer, and then there's a more specific answer. And the specific answer is to this case. I think generally, well, as we've all probably observed, we've seen compliance activity ramp up a lot since, modernisation of the modern award system in 2009. As you say, Commissioner, the awards, the modern awards weren't invented in 2009. They're the product of almost 100 years of evolution. But what we've seen in the last 15 years is a compliance ramp up. We've seen a lot more interest in parliamentary interest in enforcement. The Fair Work Ombudsman, who have mandates in relation to education, investigation, and in prosecution on behalf of employees, are becoming a lot more sophisticated and active in this space, and so we're seeing and a lot more prosecutions on accessorial liability for directors. So which is something that has always gotten the attention of corporations if the directors face accessorial liability. So all of those things have led to a much higher vigilance. But I think the specific answer is that for a very long period of time, employers have chosen to just pay an over-award amount and use a common law contract to set off the award entitlements. And I think the controversy has always been, to what extent are those entitlements actually satisfied by the paying of a contract, by the paying of a fixed salary. And I thought it might be worth, before we dig in, actually sort of breaking down some of these concepts. And I think a really important concept that's explored very early in the judgment is the fact that a contract, it's not disputed that an entitlement under award can be satisfied by a contractual entitlement. Legally speaking, that creates two separate concurrent entitlements that interact with each other. Having said that, one of the findings in the judgment that's critical is that a salary itself, for instance, an annual salary that's contracted to be paid over 26 fortnights, is not actually an annual salary. It's a fortnightly salary. The contractual requirement is to pay fortnightly amounts. And so that becomes critical. So I think often when people talk about annual salaries, and we all talk about annual salaries because that's what we understand from a market value, 80,000, 150, 200. But in real terms, the contractual entitlement is per pay period. And that's a critical piece. An annualised salary, not to be confused by the annualised salary clauses in modern awards, which provide for a mechanism for award entitlements to be annualised. And I think one of the things that's really ramped up the controversy is amendments to those annual salary provisions in 2019 that have then imposed some fairly not onerous, but fairly strict requirements on what employers need to do in order to obtain that annualised set-off. And what I think Karen and I both observed in our advisory practices at the time is a lot of lawyers saying, well, you don't need to follow these clauses because you can do it at common law. And a lot of other lawyers, ourselves included, that said, well, actually, I'm not sure you can. And I think this case kicked off in around about that time. And so I think that's really sets the scene in the sense that we have a contract and the concept of set-off, and to what extent can the entitlements be set off, but also where do things like record keeping and the rest of it fit into that.
Thanks for that. So what then does this judgment actually address?
Well, the judgment, it really, there was a number of issues, and there's a big portion of the judgment that actually simply defines the issues, and many of the issues that were raised by the parties weren't ultimately needed to be decided. But I think the critical questions were whether an annualised salary can actually absorb award entitlements across extended periods beyond that contractual payment period. The limits, therefore, of the contractual set-off clauses, to what extent can a contractual promise set off these entitlements? How does a set-off clause affect the record-keeping requirements for salaried employees? The evidentiary consequences of missing records, and the interaction between contractual statutory payments and award payment obligations. So each of those have various obligations on employers about when payments should be made. There were also some very specific things around just the general. All of those have broad application across the modern award system, but there was also some specific stuff in the general retail award about overtime, Sunday penalties, agreement clauses, and the allocation of set-off. So if you've got an over-award payment but it's not quite enough, how should that then be allocated for the purposes of civil penalties and everything else? It was broken down into parts, but I think we're looking predominantly, we're going to talk about all of it if we can. As you said, 800 paragraphs, but I think part A relating to set-off is the critical one, part B relating to record keeping, and also part C of the judgment, which was concerned with agreements within awards. A lot of the awards provide the capacity for employees and employers to agree for variation, and that featured in the judgment. I think that's really the key elements that we wanted to talk about.
Lovely. All right, as you say, perhaps one of the key parts of the judgment is about the set-off clause. Woolies and Colesworth, as would say, are paying their managers an annual salary and seeking to use the set-off clause in the common law contract. So it was a swings and roundabouts situation. So some weeks the employees worked less and they received more in the hand than they would have been entitled to under the award. And then some weeks they worked more, so the pay was less than it strictly should have been if they were being paid pursuant to the award. The employers were arguing that the set-off could be applied to even that out, and there was effectively a reconciliation period of 26 weeks. But the court didn't agree. Can you explain simply, clearly, as you've advertised, why the court took a different view?
I think I can. I'm going to try. So, first off, the two companies, they paid their salaries slightly differently. Coles was on a monthly basis, and it had a clause in its contract that said, we're going to pay you this much money, and it satisfies all your entitlements under the award, and then they listed them. And there was no, they didn't talk about across what period they could set off. Whereas Woolworths, their salary was made up of three components. They had a base salary, a car allowance, and a superannuation. It was paid fortnightly, and they had what they called a 26-week pooling period, where they were claiming that they could tot it up at the end of 26 weeks, and if there had been a swing or a roundabout, then that would all come out in the wash. The amounts the employers were paying was slightly more than what the employees would have been entitled if they'd worked the minimum wage for their ordinary hours. So let's say they're entitled to $20 an hour and they work 40 hours a week, they would get $800 an hour just for easy maths. $800 a week for easy maths. And their salary might have equated to, let's say, $1,200 a week. So they were getting more than their minimum wage. But what was also happening was they were working a lot of overtime, or they'd pick up the Saturday shift or the Sunday shift. There's all these penalties that apply. I suspect that in reality what was also happening was the salaried person was picking up the shift with the most penalty rates because that was cheaper for the store. That doesn't necessarily come out in the judgment. I just think that that's a practical reality. So the employers were saying, we can apply the set-off across 26 weeks for Woolworths, or Coles didn't actually have a period that they were applying. They just, I think, jumped on the bandwagon there. Both of the employers had set-off clauses in the contract which said we can set these off. Remember, this is a common law contract. There isn't, and we're not talking about an annualised wage clause in the modern award. And
not an enterprise agreement.
And not an enterprise agreement either. Yes, good point. Yeah, no enterprise agreement here. So the concept that a salary can discharge the award entitlements, not particularly controversial. We're okay with that. It was just about the time period in which the absorption could occur. The Fair Work Ombudsman said that the set-off can only operate in a pay period. That's all that is allowed, and that's by virtue of Section 323 of the Fair Work Act. And that particular section requires that amounts payable for work performed in a period be paid in full in that period. In this case, the maximum pay period allowed by the award was fortnightly. So you remember Coles was paying monthly, so there's already an issue there. And the court agreed. They said the set-off clause can discharge award entitlements, no problem with that, but the set-off can only operate in a single pay period, which is fortnightly. You can't pool payments over 6 months, and you can't use a future payment to cure a past shortfall, and overpayments in one period can't be retrospectively applied to an underpayment in another. The judge spent some time addressing specific wording in the Woolworths clause, and he talked about whether the payments actually required payment or just satisfaction, and he ended up repairing the clause by reading some words in. And he also addressed an argument which I found really interesting, and that was, he addressed two arguments that I found really interesting. The first is Woolworths used that an often quoted full bench decision of the Commission for annualised salary saying you're allowed to set off across an annual salary, it's allowed. But they neglected to read the rest of the paragraph that they were citing, and that even in that decision, the Commission says that it doesn't discharge the compliance with an award requirement to apply entitlements across each pay period. So even in that paragraph that they're citing, they raise that issue. Yeah, which you've got something to say about that.
Yeah, and that paragraph is one of those paragraphs that I think when you read it at the time, it's obviously the full bench of the Fair Work Commission being quite cautious because there was an absence of a superior court authority on the issue, and it's very cautiously written. But I think it's one of those paragraphs that you just keep seeing cited everywhere. Oh, look, it says what I mean.
Yeah. You've got to read on. So that's what the court said. In a nutshell, set off only, single pay period.
Right. Excellent. So has the court made other findings about set off previously? Obviously, well, not the court, the Commission, obviously. How does this case sit with the decision of Corporate Air Charter Proprietary Limited and Australian Federation of Air Pilots?
Well, the answer to that is I'm not sure. I'm not sure how it sits, and I think there's scope for some more debate here.
So just to explain, that decision occurred
in April.
So just before, just after?
I think it was just before. So April 2025, the full bench it releases this decision. It's not referred to at all in Perham's decision. Maybe it wasn't argued, or maybe it wasn't directly relevant. I haven't quite worked that out. In that case, it's about some pilots. The main question is whether standby time is hours worked. If the answer to that is yes, the next question was whether the employer could average hours, which is a little bit like a set-off, average hours across a period of time so that there wasn't an underpayment because of the standby hours. And the court found, and this has actually been appealed and it's gone up, right up to the High Court and back down again, the court found that, yes, standby hours were hours worked, and they also said, yes, you can average, but only across a year. You're only allowed to average across on an annual basis. The employer in that case was arguing that they could average across the lifetime of the employment. The court didn't accept that. So the parties didn't squarely argue the interpretation of Section 323 of the Fair Work Act, and I think that might be why it's not really referred to in this decision. But I think there is tension between these two decisions, and there may be some technical debate that can be used, maybe on appeal, I don't know. You had something to say? Yeah,
no, it was quite interesting that there was that sort of conflict between the averaging of hours and the financial set-off, because it came up in this case as well. As an argument, Woolworths ran that because the retail award provides, like many of them do, provide for the averaging of hours over several pay periods, that was used in argument to sort of support a proposition that financial set-off could be used. And Justice Perham has said quite clearly that the averaging of hours is a separate issue to the payment, and in fact, where you do have an averaging provision, let's say your ordinary hours are averaged 152 hours over a 4-week period instead of 76 over a 2, so you've got a fortnightly pay period or a weekly pay period, but you can average the ordinary hours. His Honour has basically concluded that under that averaging provision, the entitlement to overtime doesn't arise till you do the 153rd, 154th hour. And so it's at that point the entitlement crystallises, and it's in that pay period that it's entitled to be paid. And there's no correlation between an averaging and set-off of a requirement to pay. And what's interesting about that case, the pilot's case, the corporate air case, is that you've got an argument around averaging over the entire averaging hours, a separate argument saying no, it's about pay. And you have to wonder if it had been argued that the pay period argument had been argued, whether it could have been, well, who knows. But as you say, there's a tension, but it's not because it hasn't been squarely put.
Yes, it hasn't been squarely addressed yet, and that's because of how these two cases were run, I assume.
And do you think that, I'm going off
Yeah.
off script, but do you think that that then potentially is an appeal point that the supermarkets will take up? And
I don't know if it's an appeal point or whether on appeal it gives them a different way of arguing. I wondered if that's how it could be used.
Yeah, and it probably hadn't been decided when arguments finished on this one as well.
That's true, because this has been going on for several years, I read.
interesting. So Brian, what do you think are the key practical lessons for employers in relation to set-off clauses following this decision?
Okay, I think the number one is that the set-off must be expressly tied to the pay period. I think there's no dispute about that. It's interesting, we talked about what the Fair Work Ombudsman was, they have, from an enforcement, because I was mentioning litigation is their last resort, and from an enforcement practice, they've been enforcing on this basis for quite some time. I think that is the reality, and I can't see how that's going to change. So in effect, you can't rely upon salary amounts at a different time to discharge award entitlements from prior to later. And I always like to give an example in this because it's sort of hard to sort of think about in the abstract, and the point being that if you pay somebody a salary of $52,000, you can tell I like to make the maths easy, right? You know where I'm going. And over a weekly period, and that's $1,000 per week, the key issue is that if the award entitlements on week one are $1,100 and the award entitlements for the remainder of the weeks are $900, you're going to find yourself in an underpayment and contravening the Modern Law and the Fair Work Act, even though there's $4,900 paid ahead of the award on that annual basis. So that's the case as the general principle. Having said that, the annual salary provisions, if followed under the Modern Award, do allow you to assess it on an annual basis. The other thing that's really important about set-off is there needs to be established a coincidence of purpose or a correlation between the payment, the nature of the payment and the nature of the entitlement, and that should be done in the contractual clause, in the set-off clause, or sometimes called offset clause or all-up clause, and we can talk a little more about that. But I think it's a major reset for employers that saw annualised salaries as, well, a fixed salary. I don't want to call it an annualised salary because it's actually not an annualised salary, as a sort of a compliance shortcut. However, it does add, I believe, some value, and there's no annualised salary provision in this specific retail award, but for Clerks Award and for Legal Services Award and for a number of other ones, hospitality, restaurant, where there is an annualised salary provision, this decision actually adds a lot of value to those clauses now. And the sort of the 2/3 of the legal community that was saying, oh, you don't need to do it, just do it this way, are going to find that harder now to do. So it does actually, employers can reconsider the value, because then you can sail closer to the wind with your salary, because it can be done over the course of the whole year, particularly in circumstances where you've got an employee, for instance, that might have 3 or 4 weeks of the year where they're doing a lot of overtime, but the rest of the year they don't. An annualised salary provision, annualised offset, gives the employer flexibility to pay less and offset more. So I guess that's one of the major shifts that we'll see, is maybe a revisitation of those clauses.
Well, that's a good segue at this point to look now at the record keeping, which was part B of the decision, and the obligations under the Fair Work regulations, because it seems that one of the reasons that annualised salaries were attractive is because employers, and these employers were no different, took the view that it was a way to effectively avoid having to keep some of the records. So let's start, Karen, with what are the records and what are the obligations of employers in respect of keeping records?
So employers, and I think you're exactly right, they thought it was a way that they could set and forget and not have to worry about all these pesky pieces of paper. So our obligation to to record keepers found in the regulations, and we're looking specifically at 3.33 and 3.34. And there's a list of items that employers need to keep records of, but by virtue of that list, it's actually a little bit deeper because, for example, you can't know an overtime hour start and finish time unless you've recorded the ordinary hours as well. And I think people overlooked that. So we've got penalty rates and loadings, allowances, overtime hours, start and finish times, ordinary hours where they trigger a penalty or an allowance, so perhaps a late meal break or something. And then there's also an obligation to keep record of the rate of the remuneration and the gross and net amounts paid and deductions. Those ones are usually covered by a pay slip, so they're less controversial. And they weren't, I don't think they were an issue in this case. And 3.34, or rather 3.33, subsection 3, deals with records where an employee is entitled to be paid. And those are important words because in the decision, Woolworths ran an argument about whether their employees were entitled to be paid and therefore whether those records were, obligations were triggered. That's about loading and penalty rates. And then 3.34 deals with overtime.
What was everything you were going to say about that?
Well, actually, I might just go on about that that argument that Woolworths raised because.
I'm going to interrupt. Do you remember
yes.
you and I having this argument in like 2016 or 2017 on a case?
Yeah.
And we were looking at 3.34, which is, and this issue of entitled to be paid, and does that arise when there's an underlying entitlement under the award, or does it arise when there's whether you're actually paid for those hours or not? And we came eventually, after 15 minutes of discussions, came to the same conclusion in the sense that obviously if you're entitled to be paid it, that includes an offset. And one of the reasons, and it's funny, it appears in the judgment, is you can't contract out of Section 535, which is the overarching obligation, and you can't contract out of unfair dismissal, you can't contract out of parental leave. So it would be sort of absurd to suggest that, okay, we've done this set-off, so therefore that person's no longer entitled to be paid. But
yes, yeah,
it doesn't. It almost leaves it with nowhere to do. But there's more.
Well, so Woolworths ran the argument. They said, well, because we have got this contractual set-off clause and because we're paying an annual salary, the salaried employee isn't entitled to be paid, therefore no obligation to keep records. And the court just didn't, no truck with that. That was rejected quite quickly. And then I think Powles ran the argument that an all-inclusive salary and a set-off clause means that there's no penalty rate or loading or identifiable entitlement, because that's the other record keeping, that it was an identifiable entitlement that must be paid. So that requirement didn't apply, and the court again said, no way. And this is the second interesting argument that I mentioned earlier, was that Perum found the obligation to arise to keep these records and the obligation to pay doesn't arise from the contract, it arises from the award. And in Woolworths' argument, there was an internal inconsistency which he extracted. And so Woolworths was saying, on the one hand, the all-inclusive salary, that satisfies all the obligations on Woolworths to pay the employee, and that's via the set-off clause, that's what allows that. But on the other hand, in this record-keeping argument, it was saying, oh, those requirements don't apply because they're not entitled to the entitlements. So we don't have to keep records because they're not entitled to them. And Perum said that you can't have both of those arguments operating at the same time. And I was really surprised that that hadn't been picked up earlier, because it does seem to be obviously inconsistent. But also without these records, you have no way of knowing whether a salary is in fact enough to satisfy what the award requires to be paid.
Yeah.
So I've never understood how an all-inclusive fixed rate salary could have anything to do with the record keeping obligations.
Yeah.
Go ahead.
Carry on. No, I was just going to say, I was just going to say that, it's akin to just being able to contract out of provisions, which is such a well-established principle of Australian Industrial Relations has been for such a long time. But that internal inconsistency. But I think the pushback in 2019 to the annualised salary clauses was all, oh no, that's going to be too hard. You've got to keep records, you've got to keep timesheets, you've got to do reconciliations and all those things. Whereas this way, we don't have to do that.
Well, if you read that decision on the annualised salaries, that's what almost all the contributors and the submitters said was, this is too onerous, it's too much, it takes away the benefit of it for employers, why would anyone have one? And the full bench said, unfortunately, that's just one of the consequences.
Yeah.
One thing I found curious in the decision was, as I understand it, Woolworths did have the roster data and it did have the clocking on and clocking off, and going, well, what's the problem? You can work out from there whether people were doing overtime, presumably then as well the penalties that might have applied. Why wasn't that good enough?
Well, the roster itself was not, so that's just something that was set up. It was the hours that should have been worked. It wasn't always the hours that were worked. So that's not a true record. So I think that was rejected for that reason. The clock in, clock out data could be used for some items. It did tell us some of the information and it was allowed for that. They said that's a record of that particular items of the regulation. So there's no breach there, but it didn't have the necessary detail. So it didn't have when the overtime hours started. It just had, I started work here and I finished there. And the obligation is that you keep the records in an accessible manner with that detail. And so it just didn't meet the requirements.
And I think the detail, and my team made fun of me when I said this, that it requires the employer to do like a contemporaneous computation. Like you've got to not just have the records of hours, but someone in the organisation, either electronically or with their brain, needs to say, okay, well, that's more than 8 hours, so that's 2 hours of overtime. That's more than 152 in the 4-week period, so that's this. And the record needs to include that. And
I think, as he indicated, it has to be available for inspection or whatever. So you actually need to have that
readily accessible.
Yeah.
And actually, long before the case, as a cautionary tale, had a client that was found to have contravened Section 535 because of this readily accessible issue. And at the time, the electronic sort of data dump was provided to a union. And then we were trying to provide that to the court, and the associate was, what's this USB drive and all the rest of that? And His Honour, quite rightly,
you should have these records.
It's not readily accessible to me, so it's not readily accessible. And so readily accessible means organised, able to be English language, able to be accessed.
Yes, because the language is also important. Because if it's in a different language that can't be understood by the employee, then that doesn't meet the obligation either.
Which I suppose is the segue for you, Brian, that since the court has reached the position that there are these obligations even for salaried employees, what level of detail is actually required?
Yeah, so really, I think we've more or less covered it, but it needs to include a computation of how many of the different entitlements, all the different identifiable entitlements. So it really, and when we get the pushback to these annual reconciliations that need to be done under the award clauses, in fact, you've got to have almost that for everybody. You have to have the capacity. You don't need to do the sums, but you need to show how many overtime hours, what were the penalty rate loadings, what were the allowances, and even as an ancillary factor, for instance, if someone's entitled to a meal allowance because they didn't have more than 24 hours notice of an overtime shift, the court goes further to say that it's actually required to have evidence of that, a record of that notice not being given and the overtime occurring. So you need all of the underlying information to determine what the actual award entitlements are.
That's a lot of records.
It's a lot of records, but really, I think in effect what it means is that you need to do the same as with the annual salary clause. You need to be able to say, okay, the salary is every week is 1,434.30, but these are the entitlements of that pay period. You know, it doesn't, there's no suggestion it has to be a number, but it has to be all of the workings to ultimately create that number. I think that's the standard.
And so can you then perhaps elaborate really what the practical implications of these findings are? And I'm going to give you a question without notice in that. Do you think that the fact that there is now, it's been made clear, this need to keep these records for salaried employees, that there might be a move away from salarising, that's not a word, employees and a move to we'll just pay them in accordance with the time?
I think there is, and I think we've seen this already in the hospitality industry that got the first really big push from the Fair Work Ombudsman. And so happens, I used to be a chef, so I'm familiar with the industry, and I did a lot of work in this period. So 2014, 15, 16, 17, and there were some quite famous restaurateurs and chefs. Now, from what I understand from clients in the hospitality industry, they've pushed right back from salaries altogether. So full-time employees now, and it's standard in the industry to pay the 38 times the minimum as your full-time salary, but they get penalties, they get loadings. And the reason is because when they've realised their compliance obligations, there is no benefit to the salary. And I think in that industry, there's always been an element of sort of willful blindness in a way. This is the salary, that's your job, however many hours it takes, just get on with it. And I don't think anybody really minded the fact that that was happening. I also think as a cultural shift that younger people now don't have the same attachment to a fixed salary as we did when we were perhaps younger. The idea of clocking on, clocking off and being paid penalty rates, that's just, so there's not the same cultural requirement. But I think if hospitality is the example, that's definitely happened. And by the time the annualised salary clause rolled out in hospitality, which was even more onerous than the others, most of the major employers had in place already an hourly paid system. And I think we're going to see that. We're definitely going to see it in retail. I think social community services as well. That's my guess.
Interesting. And any other implications that you think?
I think the key takeaways, record keeping obligations apply regardless of salary. And this is for award covered employees. And I'm not trying to encourage employers to go get creative with pushing people off modern awards, because there's some commentary in the judgment around that. Entitlement to paid penalties, loadings and overtime arises under the award, not under the contract, and that dictates the record keeping obligation. Even irrespective of how high the salary is, if it's an award covered person, the records need to be kept. Set-off clauses do not have the effect of relieving for the reasons, Karen articulated. Separate identifiable entitlements have to be recorded. You have to have that contemporaneous computation of not just these are the hours, but what do the hours mean? And in effect, I think the reconciliations that the employers found so onerous are just going to be a feature of all award-covered employees. His Honour also made it very clear that just merely the fact that someone's managerial under that award doesn't push them out of the award. And I think while we're talking more generally, I think I see often in Clerk's Award, quite senior people are still covered. In the social community, home care and disability services, very, very senior people are covered.
Miscellaneous award.
Miscellaneous award, which had changes in around, I think 2021, which sort of broadened that, absolutely. I think in professional services, the combination of legal services and Clerk's Award, really anyone that's not a qualified legal practitioner or a chartered accountant often is going to fall into those coverage brackets.
Can I just interject there with the practical implications? Because one of the when I was reading this judgment, we're talking about people working in a store. So they're at work or they're not at work. That's easy for us to identify. But I was thinking about all of the clients that I have where there's a travelling salesperson or somebody that works by themselves in a remote location because they're a horticulturalist, or where it's not really clear, are they working right now or not working right now, and I think there's going to be a lot of pushback from those employees because they saw the annualised salary also as an example of how senior they were, because they didn't have to clock in and clock out, and they didn't have to have somebody watching over them, or, you know, the minute they tapped into their emails, is that working? Is that 5 minutes of work that then pushes them over into those overtime hours? So there's some really serious implications here that I see from a practical level.
And throwing in even, you know, commercial travellers is really interesting too, because of the high levels of sometimes commission-based pay as well, which for this same reason, coincidence of purpose, you can't say something's a commission and it's also part of your award. You can't say the Christmas bonus is
actually for your overtime.
Which sounds humorous, but it's definitely been a question. You know, when people are facing remediations, that's the type of question that employers will ask. I think what's interesting too is the implication to when we're moving towards a remote-based flexible work where you have people working from home and it's understood that, I'm going to pause and go get the kids from school, I'll put some washing on, but then I'll clock in later. When you're talking about things like minimum engagement, penalty rates, those things, I think it could have really big implications.
Yeah, have I worked my 153 hours? Am I entitled to overtime? Yeah.
Well, I'm going to clock in on Sunday morning and finish that work I didn't do on Friday. Am I entitled to penalty rates?
Yeah. It also seems to me if there is a move away from the annualised salary, potentially, well, there might, like you've given the example of young people perhaps not being as attached to an annualised salary. Banks are. So if you actually want to get a loan, you know, and you have to then establish your income, it's going to be harder if you can't produce the letter that says you're going to receive.
That's a really good point, because they do want to know what your salary is, and they don't. If you've got an uncertain weekly amount that you
then it's going to be based on past histories, and then they're not, and then that gets discounted, and so the interesting implication. Now there's two other important parts we really need to make sure we cover before our time is up, and one is about the reverse onus that applies by virtue of section 557C. And Karen, can you explain that first?
Okay. So this has really become important, mainly in our migrant exploitation cases. And essentially what it means is if the employer hasn't kept the records, what the employee alleges they work, within reason, that goes. So if they say, I worked 8 a.m. to 8 p.m, then it's up to the employer to disprove that, and with the records that they should have been keeping. So it's a reverse onus, it's important. And that's what happened in this case, because basically there just weren't any records kept. So a lot of the assumptions were based on what the employee alleged happened. And we've had a case, haven't we, where we had to go to some lengths because the 557C obligation imposed on our client the burden of disproving that this employee didn't work 27 hours a day. It wasn't quite that bad, but it was a lot of hours a day, and
but more was alleged than was actually worked. And then suddenly when you've got the
reverse onus, and if you can't prove that wasn't worked, then that will be accepted. So it's pretty serious. But very powerful in our migrant exploitation cases.
Thanks for that. And Brian, Part C of the judgment provided some commentary in relation to agreements made under modern awards. These are an important mechanism for employers to use to engage flexibility in relation to the strict award conditions. What type of agreements can the parties enter into, and how can this be done in a way that's compliant?
So this concerns specific clauses, and it's fascinating how many of them are when you actually go through the awards. Specific clauses that allow for variation. So I think one of the key ones in this case was the standard provision is that employees needed 12 hours off between shifts. Except by agreement, this may be reduced to 10. And there's a number of them in the retail award, but there's there's often ones that the span of hours, for instance, by agreement can be moved from 7 a.m. to 6 a.m., that type of thing. Now, it really focused on a couple of things, but what constitutes an agreement, that the timings related to when the agreements were made, the limitations on what it can and can't cover, but most notably is the argument from both employers that there was like an implicit waiver, that they were sort of saying, well, yes, they did agree. And I've advised clients before this case on this issue that quite often you'll sort of say, well, okay, it says it in the contract, or it's our policy that this happens. And
I was just going to, the policy argument really, I was really surprised that these two huge companies were relying on policies to satisfy that obligation.
Yeah. And well, it's interesting. I was fascinated since this case. My youngest son has done onboarding at a major national retailer, not one of these, but the other one, if you like. And not surprisingly, the contract, all of the onboarding was something that he did on his phone. It was like, click, click, I agree. Now, everyone warns you about the, don't accepting things on your phone. But really, I think the message here is that a boilerplate contract employment that is really basically coercive in nature, when you're talking about a a massive national company and a 16 or a 17-year-old, the agreement needs to be an agreement. And what His Honour found, and he looked at the ordinary meaning of agreement, the meeting of the minds, and in essence, His Honour said that where you have someone, if you're going to say somebody agreed, they need to actually understand what they're foregoing. And that is a really important point. And I think there was a quite an amusing suggestion. I don't know if it was intended to be amusing, but His Honour made the observation that all work in the modern era is consensual. You agree to work. So therefore, if you're trying to say that just merely agreeing to a roster is therefore an implied agreement to the variation of award, it has an element of absurdity to it. So consistent with my very cautious position when I previously advised, it has to be an agreement that is separately made with the knowledge that the employee actually understanding what it is they're agreeing to. So I think in that circumstance, and these are often really important, the facilitative provisions, as they're known, are often really important because, there might be an opportunity to do that extra 2 hours at ordinary rates, or do another ordinary shift as long as you can come in after 10 hours instead of 12. And that might be something that is the difference between being able to do the shift and not do the shift. And an employee might be able to understand that, if I want that extra shift at ordinary hours, then I need to agree to forego this. And that's an informed agreement. What's not an informed agreement is, this is how we do it around here. Take it or leave it. If you want the job, this is how you have to do it. And I think that's kind of the gap that I think has been
It does give enterprise agreements some more scope, though, because that could have been agreed in an enterprise agreement and we wouldn't have to go through the separate agreement for each employee.
That's right. And I suppose there's scope to argue before the Commission that the employees are still better off overall because that facilitative provision provides that. So perhaps there's some scope there. But the interesting thing was also on the onus, and that was argued quite, and the onus is on the employer to show that. And that was just discussed as being an ordinary exercise in construction, in the sense that, the Fair Work Ombudsman had the onus of proving that this clause was breached in relation to the 12-hour gap. And then if the employer wanted to rely upon that exception, like any defence, they have the onus of then proving the defence. And I think that was kind of the summary, but I think, a sensible summary. But again, having dealt with most of my clients are not spending $5 million on litigation. Most of the clients I deal with, if they're in an enforcement situation, are really listening to the Fair Work Ombudsman and having to comply with what the Fair Work Ombudsman says. And the Fair Work Ombudsman has been saying this for many years. That is, when you say, oh, well, these employees agreed to extend that to 10 hours or reduce this to 8 hours, they'll say, well, where's the evidence of that agreement? Every time. But I think that's the standard that applies in relation to that. But I think that's fairly sensible. I shouldn't be saying His Honour is sensible or not sensible. But I think that's pretty common sense, isn't it, really?
Excellent.
Yeah.
Now, look, we've probably got time just to touch on one last little point in the judgment before we see whether we have some questions from the floor, and that is, I'll ask Brian, there was some discussion about when an employee regularly works on a Sunday. What was the significance of that in the case?
And that's specific to the retail award. And really it has an impact on which roster days off the employees are entitled to, whether or not it's a regular Sunday. I think this probably has some implication across that extra week for shift workers as well, like the reasoning.
But I think the reasoning has broader application.
Yeah, and the main issue was that it was held that it was a combination of pattern and predictability. A sustained pattern, but not an uninterrupted pattern, was enough to show that applied. Rostering sufficient. Short deviations don't break the pattern. So, for instance, you have a period where you don't work and it doesn't. And I think, the message really to try and do it in 10 seconds is substance over form. That's what I was reading from the judgment on those positions. But again, it was a favourable interpretation for employees.
Excellent. Well, look, thank you both. I'm going to see whether we have any questions either from people here in the room with us or online. We have somebody managing our online personnel and no doubt looking to see. Yes, we have a question here.
I just have a question about these agreements. That's what it's been. Some say in that sort of circumstance is
I haven't turned my mind to that exact question, but I think what Justice Perham did say is that the word agreement or agreement to and all the different formulations all needed to be treated the same, and it all needed to be treated as a meeting of the mind. So I think I would generally advise against anything that's sort of boilerplate. Again, contracts are different. A lot of people have that opportunity with a contract to actually negotiate the contract. So, for instance, if there's evidence of a whole lot of, red line or markup and saying, oh, I agree to this, I agree to that, where it's something that you've agreed to, I don't know that the employer could evidence a meeting of the minds.
Some of the common law contracts also contain undertakings that say, I had the opportunity to get legal advice, I've chosen not to do this, I've done this, I've done that. So I would imagine the employer would want to rely on those undertakings when given.
Mm-hmm. Yes, we have a question from online, do we?
No, it's a question from me. Many clerks employ their chamber staff under the legal services award, and you've mentioned that a number of times. In your view, those record-keeping requirements, are they accurately captured by payroll software that people use, such as Xero, or is it something where there needs to be an additional record-keeping process applied under the legal services award? The reason I ask is because there's going to be a great interest to clerks. And I think they need to know if that's a requirement, they need to incorporate. Because I think because they're meaningful small businesses, they often rely on their accounting and payroll software to keep those records.
A bit more.
My experience with the payroll software is that it doesn't meet all of the obligations. I'm not sure if the scope is there to meet it and it's just not being used fully or whether it's not there at all. But my experience has been that it doesn't have all of the different permutations. And one example might be a late meal break, for example, that then pushes out some penalties. That's not necessarily recorded in Xero.
Yeah.
What's your experience?
Yeah. My experience with payroll software is that there's this sort of all care. We can do it all care, no responsibility. But also the configuration it's only as good as how it's configured. One thing I would say, and it's probably something I haven't properly touched on in relation to the difference between the annualised salary clauses, is that where you do your reconciliation annually and at the end of employment, there's provision for top-ups, for instance. Now, I mean, in my view, if you follow the award exactly and you find that there's a requirement for top-up and you make the top-up, you haven't breached the award. Whereas if you're relying upon a common law weekly or fortnightly salary, as it was a feature of this case, is that, you know, getting to the end of the year and realising you're $7 below in the 17th week of the year, and you make that $7 payment, making the $7 payment doesn't cure the contravention. So you've actually contravened. I think, you know, for someone employing a lot of people, and I'm not plugging my software business, but I think doing some type of external reconciliation, external audits, I think are going to be the way forward from a you know, a best practice compliance level, and only because the software can do it. But if the wrong checkbox is checked,
that I don't. If the rules haven't been set up properly, but also a lot of the software that I've been looking at recently has said you the user plug in the rule, so they're not even interpreting the award for you. So maybe you've calculated a penalty incorrectly. The hospitality award requires a particular penalty to be paid in full, regardless of how much of an hour that you work. So that it's $2.33 whether you work 5 minutes or 60 minutes. Other awards, it's prorated. And if you've inputted that rule incorrectly into your payroll system, then there'll be a breach.
Yeah, understood. That's helpful. Thank you.
Do we have any other questions? All right, well, look, thank you very much, everyone, for attending. Obviously, this decision is now very central to advising employers out there about annualised salaries, set-offs, record keeping, etc. It certainly put a bit of a rock up everyone, I think. And I don't think the story's over. As I read, the class actions are expanding to include a larger claim period. So, you know, watch the space, because there will be subsequent decisions of Justice Perham, and there may well be appeals.
Yes, there may well be. I'll go and get this autographed now.
Thank you very much, everyone.
Thank you.